3. Kindly read the preamble. In exercise of powers under Section 3, read with Section 5 of the CGST Act and Section 2 of the IGST Act, the Central Board of Excise and Customs, my lord, it has been amended to Central Government. The Central Government hereby appoints the officers in the Director General of Intelligence, Director General of Audit, as specified in column 2 of the table below, as Central Tax Officers. No difficulty here. That power of appointment is there.
Investment.
And investment thereof. This is the crucial error. So there is no gain saying that look at Section 3, additional commissioner there, or look at this notification, he is there. You have to be a proper officer. Investment should happen in accordance with Section 291. And Central Government is acting as a delegatee.
Yes.
Central Government acting as a delegatee does not exercise any plenary power. He has to be guided and controlled and ring-fenced with the substantive provision under which he derives the power, my lord. If Section 3 showed that he not only can appoint but also invest, yes, all these people are proper officers.
You mean these sections are watertight?
It's watertight.
No
Because
scope for
there is no scope for it. That is the rule of delegated legislation, that the donor of power will decide what the donee does. In fact, there is a concept in legislative history, my lord, this is called a doctrine of agency.
Yes.
What their lordships have said, based on English law, a donee of power binds the donor. So delegated legislation will bind the parliament. He speaks for the parliament. He does not exercise any independent power at that stage. He may have other powers, administrative powers, supervisory powers, maybe judicial powers. We are not concerned with that. When he is a donee of power, he exercises his power as an agent. I'll place the judgment below. This is a very relevant judgment on this particular point.
That's an interesting point, yes.
Yes. I'll just place that judgment below. Roopchand, volume 9, my lord. Page 197, volume 9. Constitution bench. Who has that? Volume 9.
Yes. And volume 9. Roopchand.
Yes, my lord. Constitution bench.
Yes.
May kindly come to
197.
page 197 is where it starts, and para 11, which is at page 200, is based on a renowned constitutional law expert, my lord Willis, who has written several books on constitutional law and who was a judge himself. Para 11.
Yeah.
The question then arises when the government delegates its power, for example, to entertain and decide an appeal under section 21(4) to an officer, and the officer pursuant to such delegation hears the appeal and makes an order. Is the order an order of the officer or of the government? We think it must be an order of the government. The order is made under the statutory power. It is the statute which creates that power. The power can therefore be exercised only in terms of the statute and not otherwise. In this case, the power is created by section so-and-so. That section gives a power to the government. It would follow that an order made in exercise of that power will be the order of the government, for no one else has the right under the statute to exercise that power. No doubt the act enables the government to delegate its power, but such power when delegated remains the power of the government, for the government can only delegate the power given to it by the statute and cannot create an independent power in the officer. It is of interest to observe here that Willis J. said in Huth versus Clark that the word delegate means little more than an agent. An agent, of course, exercises no power of his own, but only the powers of his principal. Therefore, an order passed by an order officer on delegation to him under 4 section so-and-so of the power of the government under section so-and-so is for the purpose of the act an order of the government. If it were not so, and it were to be held that the order had been made by the officer himself and was not an order of the government, and of course it had to be made one or the other, then we would have an order made by a person on whom the act did not confer any power to make it. That would be an impossible situation. There can be no order except as authorized by the act.
Yes.
And therefore the scope of delegated legislation there is very clear that the Doni is basically an agent of the parliament in this case. He has no independent power of his own. If that be the case, he can only appoint, he could not have vested. And my lord, another judgment that I had pointed out, which is Marathwada in volume 1, which is instructive for this particular aspect. For a minute, my lord, I'll read it out earlier, but in context, kindly have volume 1. I'm so sorry, my lord. Page 73, volume 1. Page 73, volume 1. Has that?
Yes.
The operative part is at page 81.
Para 20.
Para 20. Essentially, the Supreme Court says, if power to do something is with X, then Y cannot do it.
Yes.
So since vesting or appointment or assigning who a proper officer is has been conferred on the CBEC, nobody can arrogate that power to themselves. So what has happened here is the central government has arrogated the power available with the board to assign under section 291 in issuing this notification, even though the power exercised under section 3 where he has no such power to invest. Two infirmities therefore has happened. Now the submission was made by the state that under the Central Revenue Act, board is nothing but subsumed by the central government under control. It matters not. What matters is what kind of power the central government is exercising there. If it is a legislative function, can he mix an administrative power in legislative function? That's the question, my lord, we'll have to consider. Because a legislative function is independent and separate from an administrative function and a judicial function. There cannot be mix up of that. So maybe central government is the supervisor of board, but here he is exercising a legislative power, stepping into the shoes of a parliament as a Doni. He can't be using administrative power, mixing it into making it into ragbag, quasi-legislative administrative order, because then power will fall.
Yes.
And my lord, I had given the illustration that when my lords are deciding a matter here, my lords are exercising judicial function. In the chamber, my lord will exercise administrative function. So it doesn't matter who the person is. What matters is what kind of power they're exercising. So therefore, that was my submission on that particular point, my lord. Then my learned friend had relied upon in the state's compilation, page 70. Page 70 of state's compilation.
Yes.
He relied on this notification reference to AK logistics of the Jharkhand High Court, my lord.
Yes.
Kindly have para 1. What was up for challenge? The instant writ petitions have been filed under 226, wherein demand notice comes show cause notice dated so-and-so issued by respondent number 2 in exercise of powers under 74(1) of the CGST Act for the period July 20 to 22, November so-and-so to so-and-so, so-and-so, so-and-so respectively have been assailed on the ground of lack of jurisdiction. Let's see that. Neither the notification was up for challenge, nor the circular was up for challenge. And my lord knows that a judgment is an authority of what it decides, not the conclusion that emanates from there. So in both this judgment, conclusion may be that these DGGI officers are proper officers. But that is not the crux of the matter. The ratio decidendi will have to be based on what was the
judgment properly. Where is paragraphs 49 and 50?
Yes, my lord. I'll read it out.
Where's the finding?
Yes. Para 21.
But if the show cause
Yes. Para 21. Para 19 onwards, my lord. The proper officer, as has been defined under section 291 of the Act, means proper officer in relation to any function to be performed by this Act, means the commissioner or the officer of central tax who is assigned the function by the commissioner in the board, meaning thereby the proper officer will be said to be the officer either the commissioner or the officer of central tax who is assigned that function by the commissioner in the board. This is what we are saying. If the definition of proper officer will be taken into consideration along with the provision of section 168 of the Act, the commissioner, if authorized to act by the board in view of the power as conferred under section 168 of that, the commissioner or the joint secretary will be said to exercise the power of commissioner or joint commissioner construed to be with the approval of the board. The reference of a notification dated 1st July 2017, which we have challenged, has been made, upon which much emphasis has been given by the learned counsel for the petitioners. The said notification has been issued by under the authority of the Ministry of Finance, Department of Revenue, Central Board of Excise and Customs, conferred under section 3 read with so and so. They have now quoted the particular notification, my lord. Then para 22. Subsequent to the aforesaid notification, corrigendum has been issued on July 29, 19, whereby the notification which was issued on so and so was modified to the extent that in place of Central Board of Excise, the same shall read as a government, which is the corrigendum. Para 23. It is evident that initially the notification dated so and so was issued in exercise of power under section 3 and 5, but subsequently it has been modified to the said to be replacement of the word what was Central Board of Excise and Customs to be read as government. That's it. That is not an issue. We are on whether you could have gone beyond appointment to a vesting. Here they have taken it as granted the notification subsists as a valid piece of legislation and that it has been exercised by the central government as opposed to a board. Then when it comes to para 26. This court, after going through the provisions of section 345 of the Act, is of the view that as per section 3, it is the government by notification is to appoint the officer for the purpose of the Act, while section 4 confers power upon the board in addition to the appointment which is to be made in pursuance of provisions of section 3 to appoint such person as it may think to be officer under the Act. Again, so far appointment. This court, after having discussed the aforesaid statutory provision and coming to the notification dated July 1, 2017, reading it together with the notification dated July 29, 2019, is of the view that both under subsection 3 and 5, since section 3 confers power upon the government to appoint the officer to act under the Act, while section 4 of the Act confers power on the board in addition to the appointment which is to be made by the government, the board can also appoint officers under this Act. Again, they have not gone into validity. They have just relied upon the notification. Then para 29. This court, therefore, is of the view that since the notification dated July 1, 2017 has been issued in exercise of power under section 3, read with section 5 under which the board has been conferred with the power, in addition to appointment to be made by the government, to impose.
So how do you explain para 49 then, Mr.
Yes, my lord. I'll come to para 49 as well. The notification dated July 1, 2017 and February 19, 2018 thus confers power on the Additional Director General, Central Tax Intelligence or Additional so and so to act as commissioner. This is what I'm challenging. That how do you put them at par as a commissioner by vesting? It has taken as is. It has taken the notification says he's a commissioner, therefore everything follows through. I'm saying before you cross that bridge, tell us, how did you appoint, how did you vest on him? You can appoint him, no difficulty. He's appointed as a central tax officer. How did you do this vesting? And I had submitted before my lord, I had shown the constitutional construct, the governor is appointed through our article.
So your submission is that in this particular case is limited only to the challenge of show cause. And so only to the show cause, correct. The meat of the matter was not discussed at all. with regard investment of power.
That's right.
That's your case.
That's the part. That's the part. Because
And
you
so
have
the whole discourse here in the judgments only with regard to the show cause and they have just
correct narrated what the law is.
What the law is. What the notification says.
Correct. I have elevated the discussion to little above and said that yes, the notification
one step
further to say where is the vesting power.
Okay.
If they can show any judgment where vesting has been, that's right. So therefore, my lord, that is what my submission was. Insofar as this is concerned.
Yes. Next point.
Then, my lord, my learned friend has also made a reference to RC Infra, which I had dealt with at the very beginning. RC Infra was the judgment from Allahabad High Court. Learned DSG was kind enough to make that submission, where the Allahabad High Court has said, well, the assignment has to be done by the board, we understand, but central government can do what the board can do. Therefore, when central government under exercise section 3 has appointed and also invested, it is proper exercise of power. That is what RC Infra says. By the greatest respect to the learned judges, my lord. That dilutes power of delegation. The entire submission that I made, Ruth versus Clark, Roopchand, delegate is power, the straight distress that will cause to 168A, arrogating of power by the central government to the board's power, it will create a mayhem in the superstructure of the statute. So, when you exercise legislative power, you stay on course with the legislative power. When you exercise administrative power, by all means do whatever you have to do. You can fire the CBC chairman, you can hire another person, you can do everything else. But legislative power is sacrosanct. Because, Lord, the rules of engagement of judicial review of legislative function, legislative power is wholly different from administrative function. For administrative function, we'll have to show what is called either Article 14 or AK kind of principle. Judicial review goes into competency, doctrine of eclipse, Article 14, other constitutional thing, and various other things. So the scope is wholly different. Unlike a legislation, where a central government or where the parliament can exercise power to legislate using multiple entries of a legislation of list 1. It can exercise power under 52, 55, 32, etc. and come out with a composite law, which is called a ragbag legislation. That is only for legislative purposes. Central government as a delegate cannot say, in notification, I'll use my legislative power and then subsume an administrative power. That's the submission. So RC Infra to that extent has gone fallacious, my lord. Then I'll come to the pre-GST work. The submission that they have made is that, kindly have section 142.10.
One second.
Open that.
Yes.
Look, this subsection 142.10 was relied upon by both the state and center.
Yes.
To say 142.10 read with section 12, section 13, would indicate that if the time of supply is during GST era, I can levy tax. That was the submission, because in the impugned order, my lord, they had taken a categorical finding. The substantial part of the construction was over before GST. And my argument was that if you say construction is the meat of the matter, then everything happened prior to GST. Merely because I may be receiving payment during GST does not give you jurisdiction. To that, the contention was that look at 142.10, read with section 13, adequate power is here. Now let me read 142.10. Save as otherwise provided under this act. First definitive point to be kept in mind, my lord. Save as otherwise provided under this chapter. So if there is any other provision which provides otherwise, that will overrule. So it's a non-obstante clause in that sense. Save as otherwise provided in this chapter, the goods or services are both supplied on or after the appointed date in pursuance of a contract entered into prior to the appointed date shall be liable to tax under the provisions of this act. So if there is a supply that takes place during GST, not matter whether the contract was executed prior. Now how do you ascertain when the supply has taken place or not under GST? Reference was made to section 13. For a minute, my lord, I'll request my lord to jump back to section 13 so that we know what they were trying to say.
Yes, time of supply.
Yes. Their contention is the liability to pay tax on services shall arise at the time of supply as determined in accordance with the provisions of this section. Subclause 2, time of supply of service shall be earliest to the following date, namely the date of issue of invoice. So therefore the contention is, since all the invoices were raised during GST era, supply has happened during GST era, therefore I have the power under 142.10. That was the submission. At first blush, my lord, that may be correct, but that is hopelessly wrong in terms of the statutory structure. Now kindly come back to 142 subclause 10. Lord sees that?
Yes.
As I mentioned, it starts with the word save as otherwise provided under this chapter. So we have to look for if there is any otherwise provision. That provision is in the very next subclause, clause 11. I may request my lord to look at clause 11, subclause B. Notwithstanding anything contained in section 13.
Yes.
This is the clincher. No tax shall be payable on services under this act to the extent that tax was leviable on the said services under chapter 5 of the Finance Act. Which means, if some activity happened under the Finance Act in the pre-GST era, I was obliged to pay tax. I was obliged to pay tax. Then doesn't matter what section 13 says. This act cannot levy tax on you. I read it again, my lord. Notwithstanding anything contained in section 13, no tax shall be payable on services rendered under this act to the extent that tax was leviable on the said services under chapter 5. So if the hypothesis is construction happened, or not hypothesis, if the finding is, as they have, the construction happened during pre-GST era, tax was payable under the Finance Act, I had to file my returns. Section 174 is the repeals and savings, which says, notwithstanding this repeal of this Finance Act, etc., I will have the power to recover tax under that act. So that 174 for a minute may kindly be seen. (174) repeals and savings.
Yes.
Save as otherwise provided in this act or on from the date of commencement of this act, Central Excise Act, etc. All the Finance Act is also sitting here, my lord. They kindly come to clause 2, subclause C. Effect any right, privilege, obligation or liability acquired, accrued or incurred under the amended act or the repealed act or orders under such repeals or amended act. So the Finance Act liability is preserved. Nobody can say that it was not liable or covered by the Finance Act from a taxability point of view.
But there seems to be in conflict, Mr. Ghosh, with regard to reading the provisions together conjointly. So, by application as you have submitted on the date of raising the invoice, that is section 13,
right, bro.
Time of supply.
Right.
Now you're saying that 142.11b is contra to that.
142. No, what I'm saying is, just to summarize.
Yes.
Let us take, it's much easier to explain in a situation. Let's take a situation where on 1st of May 2017, a contract was entered into.
Okay.
But the supply started happening from July 1, 2017. Purport of 142.10 is, even the contract may have been signed prior to GST, yes, if the supplies took place during this era, you will be liable to tax.
Right.
This is the structure.
Yes, that's the structure. Now
the legislature, parliament realized this could lead to a conundrum that concluded contracts or part concluded contracts in the pre-GST era,
which under the other regime,
in other regime.
How do you recover?
How do you correct? Because the GST 246A does not have any retrospective or retroactive power. Parliament has not given
But
that.
in this particular case, your submission invoices were raised after the GST came into force.
Very well. But then the preservation of my liability, preservation
You
of
mean to say the returns were filed pre-GST era?
maybe I could have filed it. I may not have filed it.
But that's not obvious.
I may have filed it. I may not have. The point I'm trying to make is assume for a moment that GST Act had not come. If that be the case, construction complete in 2014. I was under Finance Act. I had to account for the tax. Tax was not payable based on my invoicing. Whether I receive payment or not, tax authority is not concerned. In service tax era, even in sales tax also, whether you got the consideration or not doesn't matter. What matters is have you done the supply. So I was subject to the Finance Act. It was taxable under the Finance Act, subject to exemptions, etc. as may be there. If that be the case, that is what the protection is given under 142(11). That section 13 point of supply will not apply to those cases. Otherwise, we will end up.
How will this proposition apply to your case? That's
Yes,
what you want.
yes,
to be
I'll
clear.
explain.
Want to be clear about that?
Yes,
Because
I'll explain.
You're advancing this argument.
Yes.
Now, so we want to understand.
Yes, brother, I'll explain.
How will this proposition that
Right,
you see
right.
will apply to your case?
Correct.
That
So-
it strikes at the very core of the issue.
Absolutely,
then,
absolutely.
With regard to whether the GST is applicable
Correct,
at all.
correct. So my submission
And it
is,
runs contra to section 13.
yeah, I will therefore build it in two parts. 142(10) applies only if section 13 applies to me.
Right.
142(11) says 13 will not apply,
Notwithstanding.
notwithstanding 13. So 13 does not apply.
Right.
If the subject was taxable under the erstwhile act, then this act is of no consequence. So time of supply, when you raise the invoice, when you did not raise, is not relevant. And the reason for this, therefore 174.
How will it apply to
yes,
your
in
case?
my case,
That is
yes,
what- that's what
I'll
I'm
explain.
saying.
Yes, in my case, on the edifice that they conclude that it is a construction having got completed in the pre-GST era, the necessary sequitur to that is that construction was covered by the Finance Act. Finance Act would have taxed it, sales tax would have been levied, or whatever else would have happened. So 142(10)(11) therefore triggers, I read, notwithstanding anything contained in section 13, no tax shall be payable on services under this act to the extent the tax was leviable on the said services under the Finance Act.
Yes.
My liability to pay tax on the whole construction activity would have accrued then and there as of 2014 because I've done the work, complete work by their own finding.
So your case section 13 will not be attracted at all.
Correct. That's why it said notwithstanding anything contained in section 13. That is why the purport of section 13 notwithstanding, because section 13 was coming in the way. And therefore they have...
Are there pleadings in your writ petition to this effect?
You know, this is a point that they have raised now. In fact, this is not even there in the adjudication order.
How you've developed your case, I mean, to that.
Yeah, because this was not a point that they had in the adjudication order even says.
There are the pleadings at all.
Correct.
Is it for this court to
No, my respectful submission is 142(10) was not even in the adjudication order.
Right.
If it was not there, it should not be taken cognizance of. But I am meeting that submission to assist the court to say that even otherwise 142(10).
But the thing is that by your action, you have already conceded to the fact that you're under the GST regime.
No, Lord, I may say something, Lord.
Yes.
Kindly have page 52
Of your petition.
of the rejoinder filed to the state. Rejoinder to the state.
Which comes contra to Yes.
So it has that page 52.
Affidavit of the state of
Rejoinder to the affidavit of the state. Our rejoinder to the affidavit of the state, because this argument has come through their counter affidavit. It is not in the adjudication order. It is not in the adjudication order. So we have dealt with by showing the reply to show cause notice. Lord, see page 52.
1 second. Still there.
Yes.
Respondents number 2 and 7.
Yes.
So rejoined. Page 50.
Page 52. This is my reply that I had given to the adjudicating authority. Annexure 1, my lord sees that?
Yes.
Yes. This is my reply.
4.
Sorry, my lord.
52. Jorabat is this.
That's right. That's right. This is my reply to show cause notice that I've annexed to our counter affidavit, my rejoinder. Now kindly have page 75, para D.
75.
Yes. Page 75, para D.
Yes. 74 para D.
Yeah, page 74. Page 75, para small d.
Okay, this is in your show cause.
Yes, in my reply to show cause notice.
Yes. Without prejudice.
Without prejudice, a substantial portion of the transaction cannot be brought within the fold of GST laws. The impugned show cause notice has sought to tax transactions that pertain exclusively to the concession agreement dated 5/16/7/2010 undertaken prior to the enactment of GST. Thus, the present SCN is without jurisdiction likely to be liable to be dropped. It is indisputable that the notice had attained provisional completion of the project highway on 28/1/2016, which clearly reflects that over 90% of the project highway was commercially operable on 28/1/2016. The road stretch involved in the project highway consists of road of 0 to 61 kilometers, a total length of 61.8 kilometers. Out of these, the road stretch of 48.09 kilometers from 0 to 48 kilometers and a road stretch of 7.85 from so on to so is completed as referred to in para 3 of the provisional certificate dated 28/1/2016. Hence, the total completed length of the road is 55.94 kilometers, which represents 90.52% of the entire road length. Further, as referred at page 18 of the monthly progress report of June 17, enclosed as Annexure 34, tendered by the noticee to the independent engineer, 98.2% construction of the project highway was completed before 30/6/2017. It therefore follows that almost the entire construction activity sought to be taxed by way of the import show cause notice have been rendered.
How was this answered?
Yes. The adjudication order says at page 122, para 4.11.
That is of your from writ petition.
Yes, in my writ petition.
Yes.
4.11. Page 122.
Page 122.
Yes.
Yes.
He says the last phase of the project was completed in January 2014, but the deferred annuity payments are being received by them on the recurring basis as per concession agreement dated so and so, which shall continue till 2031. Apart from the construction, operation and maintenance of the roads, all other rights over the road, including levy of user fee, the fee, etc., vest with NHI, as evident from the statements deposed by the signatory of the noticee and the concession agreement. Therefore, it is evident that the noticee has been providing a continuous supply of service for construction and maintenance of the road, and an annuity being paid to the noticees for services where the major portion of the service rendered is covered by the construction and maintenance of the road, which falls under SAC 9954 and therefore not entitled to exemption. There is no reference to 110.4.10 at all. 142 subclause 10.
But have you made pleading, sir, effect in your petition?
Yes. I'm just finding it out. Just tell me. I have dealt with this part.
Because this goes to the base of
at the base.
Yes.
This is why I wanted to deal with that in great length at the very opening submission I had made. I read this para 4.11 quite strenuously at the beginning. That if the work had happened according to you, construction completed in 2014, where do you get the jurisdiction to levy tax to me at all? And I had quoted Wazir Sultan judgment of Supreme Court, my lord, for a minute. If my lord may kindly see page 578 of my writ petition. Page 578 of my petition itself.
Yes.
ठीक है, keep it, flag करके आप so that my lord has that page 578.
Yes. This one, volume 2.
Writ petition, my lord.
Yes. 996, volume 3.
996, volume 3.
This is volume. No, this is volume 2. Volume 2. Volume 1, sorry. Your number is volume 1. Stop. This is volume 2. Because one doesn't have. This is this other one. Yes, that's all.
578, my lord.
Paragraph 4.
My lords are right. What had happened here, just to refresh, on the date of manufacture, additional excise duty was not in force. On the date of removal, additional excise duty came into force. Argument of the revenue was, since excise duty is collected on the date of removal, administrative action, same as time of supply, the day you raise the invoice, etc. That's the time they want to collect the tax. Therefore, you must pay the tax.
Like a tariff now that Trump has given on the date you load on the ship, that removal from the warehouse.
From the warehouse.
And and the orders have to come before certain date.
Before that. So same thing here. So the Supreme
shipment will not entail exemption.
Correct.
Unless they remove it.
They remove it.
So the tariff will apply.
Take effect, right? Under that law, perhaps. So here.
That is the whatever ordinance is given.
That's what the ordinance of the US is.
So that we can draw same analogy here also.
No, he can't. Here we can't. That's why this paragraph 4 is very important. Paragraph 4 says your levy is first, collection is later. On the date of manufacture, taxable event, was the levy there? If the answer is no, then on the date of removal, which is the collection or administrative, even though the levy has come into force, you can't collect the tax. This is the law. So in my case, the levy of service tax or whatever was on the day I completed my construction, which happened in 2014. The day I received my payment, which is the time of supply that they're talking about.
That is the crucial,
right.
That is the watershed, Mr. Ghosh, that according to us maybe, the time when you read the invoices are raised and the payments received. How do we rationalize
that? Is why the non-obstant.
How do we reconcile that?
Correct. Therefore,
that's why we are trying. Maybe you haven't made the correct period. But
my lord will have to take a view.
To understand.
Yes.
I therefore reconcile these provisions.
Yes, I will. That's what I'm saying.
That is to your case, because your case is a peculiar case.
Very well. Yes. So I therefore say that 142.11 is a specific legislative design to deal with catastrophic interpretation of 142.10. That is why they are a rider of section 13. Otherwise, there is no reason for section 13 rider. The fact that legislature knew that there could be a situation where revenue would surreptitiously go into a retroactive levy for things that have happened prior to the 101st Constitutional Amendment, prior to Article 246A was born, is what they wanted to deal with by saying section 13 will not apply. But now let us take a situation, my lord. Let us take a situation where within the GST era, work has happened. Within the GST era, contract is signed.
Yes.
Then 13 plays out to say if as per 13 the supply happened in the month of July, because that is the date when the invoice was raised, your obligation to deposit the tax will take reference to July, not the date when you signed the contract or whatever else. So if the execution of the contract, if the taxable event, if the time of supply, all three are within the zone of the GST Act, then 142.10 applies on all four.
So no issues.
If a situation there it is 142.11 triggers, work has happened, it was liable to tax under the erstwhile era, section 174 saves those liability and protection because they can proceed against me. Then the parliament said I will take section 13 out of the equation in such cases.
No, we understand.
Right.
We understand the
Correct.
legal position.
Therefore, my lord,
but what we still maybe is difficult to understand, of us or rather, how in your particular case you can squarely apply what you've argued.
Yes,
into your case. That is what that
very
is
well, Two things. Let me first read. Yeah. Let me. Yes, I will do that.
Yes.
Let me read para 4 of this judgment first, so that concept comes out very clearly. Just one second. Yeah. Para 4. Let me read it. The concept comes out very clearly. Shri Soli Sorabji, learned counsel appearing for the respondent, supported the reasoning and conclusion of the tribunal. He submitted that the duties of excise are leviable only upon the manufacture or production of goods as contemplated in entry 84 list 1 of the 7th schedule to the constitution. The mere fact that for the sake of convenience the duties collected at the stage of removal cannot and does not change the character of the tax, which is the time of supply equivalent. It is upon the manufacture or production of the goods and not on any other basis. The special excise duty is a separate and distinct levy from the central excise duties. It is levied for the first time by section 37 of the Finance Act on and with effect from 1/3/1978. Council submitted that when the goods in question were manufactured, there was no levy of special excise duty. If there is no levy of special excise duty on the date of their manufacture or production, it cannot attach at the stage of removal. Saying otherwise, the learned counsel contended, would detract from the very concept of duties of excise. Learned counsel also relied upon certain decisions both of the court and high court, etc. We are inclined to agree with Soli Sorabji. Entry 84 of list 1 of the 7th schedule to the constitution empowers parliament to make a law to provide for levy of duty of excise on tobacco and other goods manufactured or produced in India, except of course certain goods mentioned therein. Indisputably, the special excise duty is an excise duty and is relatable to entry 84. If so, the levy must be on manufacture or production of goods. That is how the words goods manufacture or production is produced in India in entry 84 have been understood by this court. Once the levy is not there, at the time when the goods are manufactured or produced in India, which is the taxable event, it cannot be levied at the stage of removal of the said goods. The idea of collection at the stage of removal is devised for the sake of convenience, which is the time of supply. It is not as if the levy is at the stage of removal. It is only the collection that is done at the stage of removal. Admittedly, special excise duty is an independent duty of excise, separate and distinct from duties of excise levied by the Central Excise and Salt Act. This levy came into effect only on and from 1/3/78, which means that the goods produced prior to that date were not subject to such levy. If that is so, the levy cannot attach, nor can it be realized, because such goods are removed on or after so and so. And kindly see my charging section, section 9. Okay, just give me section 9. Kindly see section 9. What is the levy on? Subject to provisions of subsection 2, there shall be levied a tax called the Central Goods and Service Tax on all intrastate supplies made. The levy is on the supply, so that is the taxable event. Now, if a situation happens where the supply has not happened under GST, time of supply is when the supply has made. Supply is the factum of supply. Time of supply is a special mechanism for return filing, etc., etc. But if the supply has happened in pre-GST era, the jurisdiction was under the Finance Act. The state had jurisdiction under value-added tax.
Sorry to. How much longer will you take?
Lord, I will quickly now deal with.
Because you see, today we are running a bit short of time because I have single benches. Then we have some interviews which.
Lord, gives me another 15 minutes. I'll try and complete as much, because then I.
No, but will you conclude?
Yes, but I will conclude.
No, will you conclude submissions totally today?
Not my lord, no, because I have to deal with. Then
we are sorry, we'll have.
Very well, but I'll not trouble.
We'll leave it at this point.
Very well.
As of now, but then we'll have
keep it on 4th.
Yes, we go 4th for the argument. It's a very interesting point, because he's still trying to run it in our minds. And what it's very strange, but it's sort of contra to what Trump's tariffs are.
Because that is the legislation. So he is the king, my lord.
So removal.
Yes. He is the king. In fact, this judgment, this fact that taxable event is different from date of removal is a very well established principle. In fact, there are other judgments also. In fact, in GST, there is a judgment that has come about from the Jharkhand High Court on coal cess. They applied,
because for us it's a learning process also.
Well, that is why I'm trying to assist the court as much as possible without.
I'll explain that, my lord. This runs counter to their argument that European Court of Justice That if the other component is more important, my lord, and that is rendered after.
I must clarify.
Yes,
I must
run on our mind
yeah,
also.
I will.
If
I must clarify.
If you want to,
Yes,
if your submission is that the operations are a major part
Right.
of your, of your.
And that happens for GST, my lord.
Yes.
Look, I therefore submit as follows, my lord. That is why.
means that it's your.
Yes, my lord. I therefore submit as follows. If my lord remembers, it was without prejudice.
Of course, an issue clause.
That's right. I was alluding to it because they have concluded its construction, and therefore the secutor of that. Lord, may keep it on fourth.
Only the fourth maybe because.
Yes, fourth will be a bit difficult because our chief justice is retiring the fifth.
Oh.
So we might have some.
Then, my lord, I am in some difficulty because
Can be ninth
Ninth
or
actually traveling, my lord.
So take the day of your convenience.
I'll just suggest. Quickly tell me. 11th I'm in Chennai. Tuesday. 16th I'm in Globe Up.
But the roster also might change then. Roster might change after this.
Lord, my lord, may I pray something, my lord? My diary looks very tight. I just need 45 minutes. I just have to conclude two things: alternate remedy and NCLT. These are the two things that are open. In fact, NCLT I can complete now.
We'll accommodate you on the 11th.
My lord, 11th is नहीं क्या वो करा आप देख रहे हो आप और से August. Okay. My lord, very well, my lord, may keep it on 11th then. Yes. I'll somehow manage by
further hearing 11th. Thank you.
I'm so obliged, my lord. My lord, may keep it as part heard, my lord, so that in case there is any change of bench, at least.
Oh, yeah, correct. Yes. Yes, sir, the matter shall remain part heard. Yes.
I'm so obliged, my lord.
Well, by the time might have a new chief justice.
Yes, sir.
Any mention?
Yes.
Please, Lordship. Lordship, I beg to mention item 18. The Senior Conducting Counsel is on sanction leave, Your Lordship. I pray that this matter may be taken up after
18?
18 years.
No objection.
Lordship, if the conducting senior counsel, he'll be going out of station. So if it can be fixed after in the end of September.
No objection, Lordship.
Okay. Yes.
Highly obliged.
Yes.
May I please, Your Lordship, I wish to mention item number 17, Lordship.
Yes.
I have no objection, Lordship.
After 2 weeks, Lordship.
3 weeks.
2 weeks, Lordship.
Okay. Yes.
Highly obliged, Lordship.
I have a prayer for adjournment of item 12 for the petitioner. Praying for if it can be taken up to 2 weeks, Lordship. State
Other
is
side?
in the other side.
Which one?
Item 12.
Oh, number 12. No objection, Your Lordship.
Yes.
Obliged, Lordship.
Yes.
Lordship, I beg to mention item number 14, 15 and 16.
Yes.
After 2 weeks, Lordship.
No objection.
No objection, Lordship.
Yes. Okay. 13 and 11.
My lord, I beg to mention item number 11, my lord. To 2 weeks, my lord.
Okay. Yes. Inform Ms. MS Esbarachaji. Or 10. Sorry, लेकिन present कर कैमरे यार.
Correct, sir.
Gitu. Hah? Ada kan ini? Ada apa? Ada witness kita. That one. Ah ya, saya interview orang. Okay.
Supplementary list item number 1.
Yes.
May I please, Your Lordship, this is
Which district is this?
East Khasi Hills,
East
Your
Khasi Hills, Lordship.
East Khasi Hills. Yes, the other matters when they're coming up.
On the 10th of September, Your Lordship.
Yes, correct. MS ADCM issue notice. MS Ailingwa.
The Advocate General, Your Lordship, will be there in this matter.
Yes,
He's unable to
excellent.
join, Your Lordship, at the moment.
Notice issue to respondent number 2. List on 10 September.
Yes, Your Lordship.
Thank you.
Obliged, Lordship.
Item number 2.
May it please, Lordship.
Yes,
Lordship, this is the case. Could me remember that contempt petition was closed on the ground that one letter was produced by the government. So against that we filed
The
an
caveat.
caveat is there.
Caveat against what?
Against the
Constitution of the new managing committee.
new committee. In fact,
he's a respondent in the main writ petition.
He was the respondent.
he was implicated as a respondent.
No, in this. Yes, yes. You
In the
are
main writ petition, he was the.
No, here-
he was impleaded as a party, Your Lordship.
here and the new one.
No, new one to already he's the
He's
party.
already there as
He's already there.
respondent for 5.
He's already there.
Caveat filed on behalf of the caveator who's also been arraigned as respondent number 5, the current writ petition. The caveat stands discharge. Yes. Yes, Mr.
Please,
Kurish.
Lordship. Lordship, this is the managing committee, the outgoing managing committee.
We have filed
White annexure 20 by page 26 annexure 2. We filed a proposal, submitted a proposal to the district education officers.
26.
26 annexure 2.
Yes, yes.
This was submitted to the district education officers, and district education officers forwarded this proposal to the directors. Number 2. That is
Remember this matter is regarding that Marori Panchayat
Marori Panchayati. It was
claiming to be the sponsoring body of the school.
sponsoring body. It was forwarded to the director. Thereafter, what happened? The director did not take any decisions on the matters. Then I filed a petition before the Honorable Court, and Honorable Court has directed the director to take a decision. Then I'll start from,
Where's the decision?
yes. This annexure 9, this is the direction given by this court.
Page?
Page 200. This is very important. The direction give 200. Page 200, yes. The judgment and order starts from page 201. It says the brief facts of the case are that the terms of the last managing committee of Rai Bahadur Hindi Secondary School expired on 3/2/2024. An outgoing managing committee before the expiry of the terms had 31/10/2023 submitted a proposal before the respondent 2 for reconstitution and approval of the managing committee for a period of 3 years with effect from 4/2/2024 and 3/2/2027. However, in spite of the expiry of the terms, no approval was granted by the respondent 2 for the said constitution, which prompted the petitioner to approach this court by way of these writ applications, praying for direction to issue to the respondent 2 and 3 to pass necessary orders, approvals. MF Qureshi Learned Counsel for the petitioner has submitted that though the proposal had been submitted well before the expiry of the terms of the outgoing managing committee, wherein all the necessary particulars had been submitted by letter dated 31/10/2023, the respondent number 2 and 3, however, did not accord the approval on time. The learned counsel submit that everything had been observed as per the procedure, including the fact that the outgoing managing committee was the body which has made the proposal for reconstitution. He further submitted that the reason given by the respondent of the affidavit and proposal had not been cleared due to the fact that same had been objected by newly pleaded respondent 4 would be of no consequences, as it was up to the respondent 2 and 3 to take a decision in the matters. The learned counsel then submit that there has been no managing committee for over a year, which has affected the management of the school. Just would serve if the instant repetition is disposed of, directing the respondent 2 to consider the matter on the basis of the proposal as submitted and take a decision. Mrs. T. Yangi, B. Learned AAG, assisted by I. Langwas, learned counsel, appearing for the respondents, has also submitted that as per the matter yet to be decided by the competent authority, the respondent number 2 direction may be issued that the matter may be examined and orders passed in accordance with the law. Mr. Jindal, learned counsel, for appearing for the respondent 4, the association which has raised rival claim of being right sponsoring body, then not having any objection to the disposal of the writ petitions in terms of the submissions of the learned counsel for the petitioner, and the learned AAG has however submitted the consideration and disposal of the matter by respondent 2 should be strictly in accordance with the acts and rules. Having heard the learned counsel for the parties, this court notes that this writ petition has been filed on 30/1/2024 as no approval has been forthcoming on the proposal for reconstituted managing committee of the school, whose term was to expire on 3/2/2024. This court then, by order dated 1/2/2024, due to the impending expiry of the terms of the ongoing managing committee, directed the respondent 2, 3 to look into after the affairs of the school in interim situation which is continuing till today. The instant matter then stood delayed due to the fact that the respondent 2 for the Maori Panchayat had sought implement in the instant case, which was allowed by this court on 7/5/2024. Thereafter, after pleadings has been exchanged, completed, a year has already passed with the issue still lying unresolved. This is the direction given. As observed earlier, the petitioner managing committee has come before the court only with regard to the non-grant of approval of the reconstituted managing committee. It is not case where the writ petition has been filed impugning any order passed by the respondent 2. As fact can seen from the affidavit of the state respondents, a decision was yet to be taken, as there was a counter claim and proposal put up by the 4 to reconstitute the managing committee. As therefore, there being no real point in issue to be decided by this court,
That's okay. Then what happened?
This direction is given. Now, Lordship, after the direction is given by this court, the directors, respondent 2, issued a letters. This is the 205. 205, type copy is not eligible, type copy is annexed. 205A.
Yes.
Here, in fact, the court has given direction to the director to take independent decisions, but what he said, in pursuance to the government notifications, letter dated so and so, and in compliance to the High Court, Honorable High Court of Meghalaya in WPC, both the President of the Managing Committee and the Sri Mahabir Prasad, Secretary Marwari Panchayat, are hereby directed to appear before the undersigned and to file their claim, objection, also bring all relevant documents including school records with papers. This is then the parties, they file a show cause. I also file my show cause. My show cause is in 2000, page 206. 206. Then the matter was still no decision was taken by the directors. Thereafter, I filed a petition for contempt that why they are delaying the matters and yet has not passed an order. So during the course of hearing, the contempt was closed only on the production of the letter dated 13 August 2025, that is page 212. In the 212, the page, because there was a hearing, there was a show cause filed by the respective parties, but the order passed in these letters doesn't say anything about the decision taken by the number 2. In compliance to the Honorable High Court judgment orders passed in WPC, the Managing Committee of Rai Bahadur, represented by the Presidents, State of Meghalaya, as per the direction from the Department, white letter so and so, and in continuation of reply letter so and so, I am to submit the proposal for reconstitution Managing Committee of RBI as proposed by the sponsoring body Marwari Panchayat. The decision has to be taken how the Marwari Panchayat, coming for the first time claiming to be a sponsoring body, what was the ground taken into consideration, what was the decision
they
taken.
Are the sponsoring body.
They say, but there is no order passed in this regard.
Now this order says, I am submit the proposal for reconstitution and managing committee of RBA, so and so as proposed by the sponsoring body, Sri Marwari Panchayat Shillong, enclose the names of proposed office bearers RBA. Now where's the finding that they are the sponsoring body?
There is no findings. So this is the only letter issued by produced before the Honorable Court. On the basis of that, the contempt was closed.
Are you sure that you took part? You filed your
yes. This is
that time before
the show cause is here.
No, you filed your show
yes.
cause.
In fact,
there was no hearing.
I went personally.
They heard you on
they heard me. Both the party were heard.
Thoroughly they were heard.
Thoroughly heard.
And then there's no order.
No order passed.
Body.
Nobody passed.
Sure about that?
Yes. Because first the party, they went by themselves. Because my party...
Is an order
I have not seen any order, Your Lordship, here in this writ petition.
No, but
this letter which is under challenge is a letter of, it's just communication. And it has been put up for approval, Your Lordship. So, as of now, we don't even know whether this managing committee has been approved or not by the department also, Your Lordship, by the government.
Yeah. Because this is the only letter on the basis of that.
Instructions on this.
To say. At this stage, we're not going to hear you. Just pass orders.
We need to take instructions, Your Lordship.
Come back with instructions as to
then we
yes, heard Mr. M.S. Qureshi, Learned Counsel for the petitioner. M.S. Yani is present. AG is also for response 1 to 4. And Mr. S. Jindal represents by caveat the respondent number 5. As such, notice complete, all respondents stop. Next paragraph, the grievance writ petitioner are submitted by Mr. M.F. Qureshi as submitted panel counsel for the petitioner is that though this director of school education is respondent number
2, I think.
2.
Number 2.
He also heard you.
He heard me, yes.
There was number 2. In the matter of the constitution of the RBA Hindi Secondary, the Managing Committee of RBA Hindi Secondary School had heard the contesting parties. Has by parties, no order has been passed.
It appears.
However, a letter dated 13 August 2025,
which is under challenge, Your Lordship,
which is impugned in this petition, has been issued. Stop. What is your prayer?
Without adjudication, my prayer is that in the meantime not to give effect to this letter.
Yes, he submits that the letter seeking approval does not reflect the fact that there was any adjudication as to who is the correct sponsoring body for the said school. It therefore plays an interim, the said impugned letter dated 13 August 2025 will not given effect to. Stop. Next paragraph. MST Yang EB and AAG submits that at this stage it appears no approval has yet been given to the management committee, and she prays that she will allow to obtain necessary instructions by the next date. Next one is S. Jindal for spot number 5. Also has no submission except that perhaps instructions may be received so that the correct picture may be correct picture may be
brought before the court.
Yes, correct picture be put before the court. Stop. Next one, in consideration of submissions of the counsels for the parties. Stop. List is matter on. When you obtain?
2 weeks, Your Lordship.
2 weeks. This matter after 2 weeks.
But in the meantime,
to enable the London EAG to obtain specific instructions on the said letter, and as to whether there was any speaking order generated on the adjudication that had taken place between the
rival claimants,
between the petitioner and the respondent number 5.
My Lord, if I can, my Lord, if this honourable court is intending to pass some sort of stay of that, I may be heard for a minute, because I have strong.
No, there's no. We're not going to pass the stay. Yes, no. Because only we want to know whether in the adjudication process any.
But Lordship, what I must submit,
whether
Lordship,
this has been approved or not.
And if an order was generated, there was.
It should be communicated, but there is no communications at all.
No, we will tackle that. Yes.
Or if it's communicated to the parties, Lordship, also. This communication also very important.
Stop. It is further provided that in the interim, the status quo shall be maintained.
Yes.
Item number 3.
What is this?
This is also another matter.
My Lord, a fairly similar matter regarding
by whom?
My Lord,
Oh,
he is a
rules
respondent.
reversed.
very much reversed, my Lord.
He's a party in the minute petition.
Yes, he was. Yes,
Same order, like in the petition filed by.
matter is different. I'll explain how, my Lord. I'll explain how.
Read as respondent number
5, my Lord.
5 in the unit petition. Caveat stands discharge. Yes.
My Lord, this is the second round of litigation. I'll just take a minute to highlight the background. If Lordship, so in this matter, my Lord, as per rules, strictly as per rules, as per Education Department rules, the Secretary has to forward the proposal for reconstitution of the Managing Committee, my Lord, strictly as per the rules, my Lord. In this particular matter, before the
outgoing
secretary. Now, in this matter, the then outgoing secretary, my Lord, for whatever reasons, did not forward any such proposal. He was repeatedly reminded, my Lord, page 17 of the writ petition. Page 17, my Lord, was the last such reminder, my Lord.
Yes.
This reminder, my Lord, was sent by petitioner, who was then the outgoing president at that time, my Lord. There was no response to that. There was no meeting convened, no elections held, etc. Having no other option, my Lord, next page 18, the petitioner, in the capacity of then president, outgoing president, submitted a proposal. And this proposal, my Lord, strictly as per procedure, everything is there, paper publication, my Lord, etc. All requirements have been complied with. This proposal, my Lord, was challenged by today's respondent number 5, the secretary, the then secretary, by filing a writ petition. Writ petition, my Lord, had come up before my Lord. Page 51 is the disposal order, my Lord, of the previous writ petition.
Yes.
Relevant portion, my Lord, page 54.
Yes.
Lordship has quoted the rules 4 and 5 of the Education Department rules. Then para 6, my Lord.
Yes.
The above quoted rules mandates that Secretary of the committee shall intimate to the Inspector of Schools the actual date on which the term of the existing committee expires and shall forward along with it the names of the newly elected members, the election which should have been held well before time. Accordingly, as the point in issue is very short, this writ petition is disposed of by cancelling the recommendation as made by the President, and the petitioner secretary is directed to convene the election at the earliest for reconstitution of the managing committee and to submit the names accordingly in accordance with law. The writ petition is accordingly.
What happened after that?
My lord, this Lordship's order was carried to the division bench. Division bench, my lord, next page. Page 57, last paragraph, if I'm allowed to read, my lord.
Yeah.
We think that the ends of justice would be subserved if the proposal as sent by the appellant is considered by the government. While considering the proposal, it will first examine, after hearing the parties, whether the proposal has been sent by the right authority. If it finds that the appellant had the authority to send the proposal, it will consider the process the same for which no hearing need be given. If it finds that the appellant did not possess such authority, the government will send the proposal back to the school. Thereafter, a fresh proposal may be sent by the authority having power if so deems fit and proper. The appeal and the connected application so and so according to dispose impugn judgment set aside, my lord. So there was a direction from Honorable Division Bench that you consider my proposal, the appellant, that is today's petitioner's proposal.
Then,
we filed, my lord, we filed representation, etc. Matter was processed by the government. I will not waste too much time, my lord. Page 64 is the last, the order under challenge, my lord. Page 64, order passed by respondent number 2.
Yeah.
I'll direct Lordship's attention to para 3, my lord, clause 3. Yeah. Issues for consideration. Whether Shri Mohammed Zahir, today's petition.
So now it was sent back as per page 66.
Yes.
The secretary is directed to convene. Have you sent? Why didn't you convene a meeting then?
No. After complete, I'll just say.
My lord,
this is the decision taken by the director.
I'll just take a minute.
And it is taken last paragraph.
I'll just take a minute, my lord. Let me finish, my lord. Para 3, my lord. Para 3, issues for consideration. Whether Shri Mohammed Zahir, President of the expired managing committee. I'll request Lordship notes this, my lord. Expired managing committee had the legal authority under the relevant rules to forward a proposal for reconstitution of the managing committee.
Come to conclusion.
My lord, description is there. I'll go to para 6, my lord. Page 66, reasoning and analysis, my lord. The rules clearly vest the responsibility of forwarding names of elected members and initiating the reconstitution process with the secretary of the managing committee. B, there is no provision in the rules that grants the president of the managing committee the authority to take on the responsibility of submitting the names of elected members for reconstitution purposes. While it may be inferred that the president's actions may be seen as an effort to avoid administrative delays, however, even if well-intentioned, they cannot bypass or replace the established statutory procedures outlined in the rules. In compliance with the directions of the Honorable High Court, an independent examination of the matter was conducted. On such examination, the undersigned finds that the proposal was not submitted by a competent authority. Conclusion and order. In view of the above, the proposal for the reconstitution of the managing committee put forward by Mohammed Zahir is rejected. The proposal is returned back to the school. The secretary of the outgoing committee, she so and so, is directed to convene elections, submit so and so, my lord. My lord, I'll just direct Lordship's attention to two things, my lord. One, my lord, para 3, I have been correctly classified as president of expired managing committee. However, in the conclusion, respondent 5 has been classified as the secretary of the outgoing committee. He stopped being the secretary of any outgoing committee on 18th October 2024, my lord. So by way of this order, he has been re-elected as the secretary of a non-existent committee, my lord. A committee that does not exist since 18th October 2024. That cannot be done, my lord. Through administrative action, you cannot appoint the secretary and give him the power to...
There be some tangible authority, you will convene the meeting. That's all.
My lord,
because the thing is that reconstitution is not a question of approval of you as secretary of the new managing committee.
My lord,
the question it has to be something that an exercise has to be conducted, whereby a sponsoring body is gathered, and they parents, guardians, so on and so forth, and they say, okay, say A, B, C, D will be.
My lord, which brings me, my lord, to my second point. The view has been taken by the state that the rules say secretary has to forward.
Yes.
The rules do not say only the secretary has to forward. And that is crucial, my lord, because in this case, the circumstances were such. I mean, there has to be provision for a situation, my lord, where rules may say secretary shall forward. If the secretary does not forward, there cannot be a vacuum created for the inaction of the secretary. Then essentially, my lord, the issue that is being put forward before this honourable court through this writ petition is to adjudicate, to decide whether this provision, Rule 5 of the Assam Education Rules, should be read the way it stands without any addition, or is there provision, is there scope to provide for a situation where there is inaction on the part of the secretary, thereby.
Instances where this has happened.
My lord, as of now, no. My lord. As of now, no. But I'm confident this will not be a unique situation.
One thing, what is paramount is the interest of the students.
No, absolutely.
There must be a proper management committee in the school.
Absolutely.
Now, if we are going to relegate, these
absolutely,
whatever these actors and players in the management committee, in fighting for the little ego and whatever little politics,
my lord, I could not agree with
the detriment of the management of the school and the teachers are teaching there. I mean, the school looking at a larger picture, we'll just.
My lord, I cannot.
We can iron out all this.
My lord, I cannot agree with this honourable court. My lord, I cannot agree with this honourable court more, my lord. I am also completely in agreement that the functioning or the interest of the functioning of the school interest. It's paramount, my lord, absolutely. Yes. Now, what has happened subsequently is, it appears, my lord, we are not sure, but it appears some elections were held and proposal was forwarded. Maybe the proposal has been accepted also. So right now, my lord, I am only asking for the issuance of notice, only for this honourable court to decide that issue, my lord, whether that rule has to be read in black and white the way it is, or there is provision to provide for a situation, to address a situation that emerges by law.
Have you already submitted a proposal?
Yes, already submitted, and it is the approval.
Let them come instructions.
My lord, the only other request.
Then you can challenge the constitution or approval or whatever.
My lord,
there is no provision that the president can also.
There is no provision, and that is why I'm.
That's the finding of this.
This is just a power play.
Like, okay, fine. Before the division bench, whatever orders you have,
that gave us the courage to come back again with the same issue, my lord. I am only requesting, my lord. I'm only a small request, my lord. A small request. Yes. If the whatever steps are being taken by the state towards reconstitution, etc., my lord, I will not stand in the way. But whatever steps are being taken should be made subject to the outcome of these proceedings, my lord.
Everything's outcome.
If lordship can kindly observe that, my lord.
Cause of action too.
No, that you can't put a sort of a sword,
No, not a sword, my lord. Not a sword. Not a sword. Just a safety mechanism, my lord.
Issue notice. MS Tiangi B letter EAG with Jirinja present behalf 1124 and Gavita who has been arrayed as 105 represented by Ms. M. Qureshi. As such, no notice required. So you are challenging this order per se?
Just this order. Just this order.
The grievance of the writ petitioners with the order dated 5th August 2025, which has been passed in pursuance to a judgment order dated 13/5/2025, passed at the division bench of this court in writ appeal number 72/2024 to decide a dispute between Muhammad Zahir, the ex-president of the school management committee, and respondent number 5.
Ex-secretary.
The ex-president, and number 5 was the ex-secretary of the early management committee. Mr. S. General submits that there is interpretations required as to whether it's only the secretary who can forward a proposal for reconstitution of the management committee as per the relevant rules. Next paragraph. What is your prayer?
That whatever steps are taken, my lord, should be made subject to the outcome of these proceedings.
Submits that whatever steps taken should be made subject to the outcome of the petition. Next paragraph. MST Leonard AG is that she will have to obtain instructions on the matter as to whether other events have transpired in the meantime. Next paragraph, Ms. M. Qureshi.
Already constituted and taken over charge.
That the petition has already been rendered infructuous in view of the fact that the management committee has already since been constituted and put up
taken over charge.
And they've taken over charge. And also taken over charge. Next paragraph. Having heard the consequences circumstances, this sort of 2 weeks for instructions or affidavit. Yes.
Item number 4.
To be made subject, my lord.
Yes, that we recorded your submission.
Obliged.
Yes.
May it please your lordship. Your lordship, this matter is for non-payment of legal fees bill by the ROC, your lordship.
Who's the lawyer? Or who's the lawyer of this court? Yes. Now this Mr. Day, we are showing the way for all of them to come. Now we'll make you file money suit now. There's all disputed facts. Just because you're a lawyer and this court is very compassionate, very, what do you call it? Yes, about all these cases. First case was whose case?
Against UGC. It was.
Your case against UGC. There was another case also.
I was for the respondent, and then I have filed a case against UGC.
Same in this case also.
This case is against for
ROC.
Oh yes.
Service matter, and now it is.
You take instruction. I will send for mediation. Heard MS.
Peak motion.
Your peak motion. You should notice Ms. Adebnat is present. Your fees are being paid. You also file next petition. Ms. Abdul present accept notice behalf of respondents. The foreign is called for. Yes, after 2 weeks or 3 weeks for instructions. Otherwise, you say this is a matter. Next paragraph. No, forget this. After the thing, you tell them that this court is still in mediation, or make them come before court. Yes.
Item number 5.
Soon against private clients start filing also. We can't entertain these kind of business. Just it's out of total outside the purview of jurisdiction also. Yes.
May it please your lordship.
What is after?
Lordship, this matter we're challenging the CAT's order. I believe it has been listed wrongly.
Wrongly listed before the single bench. Single bench. The instant matter is, who's in charge of listing? What about inside listing? Something. This is really. This is a matter before the division bench. Yes, as it is. It is a petition directed against order of the Central Absolute CAT. Yes. Sure, we call them. Okay. That's the order, isn't that? Very submitted currently. I had order with number 6.
Okay. Item number 6.
Please, lordship.
Yes.
Item number 6.
Yes.
Lordship, before the petitioner starts, lordship, I'm praying if your lordship could kindly have this matter at the end of the board, as the DSGI is currently on legs.
Have you received a copy of the writ
yes,
petition?
Lordship, we've received.
End of the board. End of the board means after 2.
Highly obliged, lordship.
Another thing, you have filed an interim application without even by email. It is not permitted. It has to be a correct procedure. You do e-filing also. You file an interim application by email. You kindly find in the proper format and correct procedure.
Yes, I definitely do that.
We'll take it at another board after some time. We'll call it out again. Because the DSGI is busy in the other court. Yes.
Okay.
Other matters. Pardon to start this. He's still on legs.
Yes, Lordship.
Yes.
Lordship, I'm praying if the matter can come up tomorrow, Lordship.
Oh, he's here. Yeah, Dr. Muzika, what instructions do you have? What is this?
My lord, the first one is the application, my lord, submitted by the petitioner.
Yes. Yes.
Now, my lord,
Yes.
there are 45 seats in total, my lord, in this program.
What program is this?
This is 5-year integrated MBA, my lord. The first time this has been introduced in time.
5 year, after 12.
After class 12, my lord.
Yes.
So, my lord, the petitioner applied as a SC candidate, my lord.
As a?
Scheduled caste candidate.
Okay.
And if your lordship kindly sees the last page, my lord, this is the merit list of scheduled caste candidates.
So the thing is that, see, she is applying as, you're applying as, yes. Not transgender, but here shown as SC.
No. The gender categorization is different from the caste categorization.
So this is your application, correct? You don't have a local counsel. I think you better take assistance of some local counsel. Because see,
I would like to briefly place the facts and submissions before the Honorable Court.
Of course, we'll allow you enough opportunity to place the facts, but the only thing is that now, what is your instructions?
Well, my
do you
instruction
do you have a transgender?
My lord, there is no transgender category under the government media policy, my lord, as of now.
Yes. Just wait, please wait. Yes.
My lord, IAM follows central government registration policy, my lord, which is 15% scheduled caste, 7.5% scheduled tribe, and since there is no OBC in Meghalaya, my lord, we are not following OBC for Meghalaya. 10% EWS, that is All India Policy Merit for Reservation. So in that pattern, my lord, scheduled caste, there are most only 7 seats reserved, my lord, out of 45. Now, the petitioner's ranking, if lordship kindly sees the third page, my lord, was waiting list number 8.
Waiting list number
8.
Where is that? Here in this?
The third page, my lord.
This is the last page.
The last page, my lord.
It doesn't show any number. Okay, 8. Okay. 1. Yes. Okay, 8.
So now, now it has reached number 6 till yesterday, my lord, because some candidates are dropping out, selected candidates. So as a waiting list candidate, my lord, if it happens, my lord, the petitioner gets comes within the zone, my lord, they'll get admission.
So she's number 2 in waiting list now. So you're number 2 in waiting list.
Number 6, my lord. Number 6 now, my lord.
Number 6. Okay. The thing is now.
And we don't have any
claiming admission under, if there's no quota for, the government of India doesn't have a quota for transgender persons. That means how are you claiming that? Yes, what do you have to say?
Yes, Your Lordship. In the Services Union of India 2024, the Honorable Supreme Court categorically held that transgender persons have the right to self-identify their gender and directed governments to treat them as socially and educationally backward classes. To extend reservation in educational institutions. This was a procedural delay from UGC and Union of India
yes.
that they are not implementing horizontal reservation for transgender candidates. That's my submission.
Well, it's a very serious policy decision matter, my lord.
So we understand this policy decision. The thing is that what steps have been taken by various institutions to implement this judgment? We are aware of the judgment also, yes.
So, my lord, what I gathered going through judgment, my lord, there was a direction. Now some states had implemented. Delhi state, it appears that they've implemented reservation policy. Meghalaya state hasn't, my lord, till now. The central government hasn't till now.
Yes.
So we are bound by the central government
So is
council.
there any chance of the petitioner getting a seat under is?
My lord, we still have a week's, more than a week's time, my lord. So it's luck and chance, my lord. If the petitioner gets
under
into
the transgender quota, that means you're not entitled to any seat as per the policy prevailing. That you have to challenge it now. Yes.
Policy is discriminatory and arbitrary and
Of course, yes, we understand that. But the thing is that you do not have a system in place that allows lateral or horizontal admission for transgender persons. So that means they cannot accommodate you in their present regime. Correct. Now what you're asking is fine, that you're a transgender person, so you should be given due consideration in view of the judgment. Some other states have also adopted this policy. Now the Senior Council has submitted that in the waiting list you are number 6 now.
My lord, sorry, my lord.
6 have dropped out.
Originally 9th, my lord. Now he is at number 5, my lord.
Now you're at 5. Okay. Let them file affidavit.
Your Lordship, the update I received from I am Shillong, I am at 8. I did not receive any email which says that I am on the waiting list at number 5.
As on today, is number 5.
Now, as per instructions, here waiting list number 5. We'll take this matter. Let them put instructions on affidavit. Yes, I heard petitioner was appearing in person. You don't have local counsel?
I do not have local counsel. Financially disadvantaged, Your Lordship.
We can appoint someone to assist you. Any counsel who's ready. Yes.
Mr. Sen can.
Yes. You see. Yes. Please come forward. We have a very competent counsel, Mr. Sibashish Sen. He'll assist you as local counsel. Okay. And then the court will provide him. Yes. Will provide you his details. Yes.
I just want to request one.
Yes.
The academic session is set to commence on 1st of September. Any delay will
That we can't help. You're on a larger issue. You understand? Let's hope that you get your admission by being the waiting list. Yes, heard the petitioner person. Stop. As the petitioner person does not have a local counsel, Mr. S. Sen.
I'll request Your Lordship to let me please place my facts and submissions here, because it is a direct violation of my fundamental rights under Article 14, 15 and 21.
You see, that has to be heard. You have to understand that. We're not passing interim orders because even your interim application is not in the proper form. See, as per the e-court filing rules also. So unless we have a petition that is complete in as per procedure, then we take up the matter. You take a local counsel who will assist you. You can argue yourself, but who will just help you, in along the way. Right? Yes, her petition person. Stop. We issued notice yesterday, correct?
Yes.
Yes. Dr. Mosika today on behalf of the respondent number.
But notice formally was not issued.
Number 4. Yes.
God, understand also what respondents. 1, 2, 3, 4.
All 4.
Yes.
Yes, Dr. Mosika.
But except UGC also there.
Submits
1, 2, and 4.
He will be presenting the respondents numbers
1, 2, and 4.
1, 2, and 4. Stop. Notice to issue to respondent number 3 within 3 days. Stop. As the petitioner person does not have a local counsel, Mr. Sibashish Sen has volunteered to assist the petitioner in the instant proceedings. Stop. Ms. Dr. Mosika, DSGI has also submitted that at present there is no policy in place with regard to admission of transgender persons, and that the petitioner who has applied under the scheduled caste category is now placed number 5 in the waiting list, and there is a possibility that from that quota itself admission may be possible. Stop. Only list this matter after.
Petitioner is not interested in the seat, more interested in small things.
Yes.
Yes, I'm sorry to interrupt Your Lordship. I just want to place this submission that if It is not about me, it is about my whole community.
Of course, we understand, we'll hear you. Just after 2 weeks, yes.
It cannot be based on love.
Yes, after 2 weeks, yes.
This item, on a previous occasion, my learned senior had indicated that the union wanted to file an objection, cross appeal, I believe. That's not on board yet. I would pray that this matter be listed next week for admission hearing.
The request was also this matter after one admission hearing.
Highly pledged.
Listen. Yeah, ma'am. What else can we say?
This was a transfer petition, Lordship, required to place the argument. I'm praying for some time to complete my research on the issue, Lordship.
What research?
Issue is whether the victim in a murder case is non-tribal, complainant is tribal.
I had pointed out that on the last occasion.
Mr. S. Maintainability allowed further
2 weeks, Lordship.
2 weeks? 2 weeks time to prepare himself on the point of maintainability. Yes.
Much obliged.
Yes. Should I rejoin the file?
No, Lordship, I'm praying for 2 weeks.
How many times have you prayed?
This is third time, Lordship.
Okay. 4 or 2 weeks time allowed for rejoinder. I see.
5.
So this matter can be placed for hearing as all the pleadings are complete.
As the pleadings are complete, just a matter for hearing after 3 weeks.
As per your Lordship's last direction, I was to write to the Commission asking them to keep my representation in abeyance. I've already written. This is a copy of the email, my Lord. This may be made part of the record.
They've kept it in abeyance?
We haven't received any order yet. This was sent on the 21st of August, this email.
Yes,
can you see the third last paragraph?
Ms. S. sent today has submitted that as per the directions of this court, as allowed by this court, the writ petitioner has since written to the National Commission for Scheduled Castes to keep the representation in abeyance. An email communication to this effect has also been produced of the same taken on record. This after 2 weeks for instructions and for further orders. You find out whether if kept in abeyance.
Please, Lordship.
What was it? Have you received the NET certificate? Then how come the set has been issued?
Exactly, Lordship. We've also replied to the email, but until now there's nothing, Lordship.
Strange. You filed affidavit, correct?
No, I didn't file it.
Then who filed affidavit?
This affidavit filed by UGC, that's number 3.
By the?
And UGC, University Grant Commission.
Who's the opinion of UGC today? Are you aware of the case at all?
So I don't have any instruction in them.
You don't know what the case is about? Very good.
So last question, this is saying this respondent of 4 will be the main persons to issue that.
Who's number 4? Dr. P. Agarwal?
Nobody has appeared, Lordship. Till date.
Where's that affidavit?
If any affidavit filed, no copy is given to me.
No copy given to you? Yes, Dr. P. Agarwal appeared. We listed on Monday. Yes, Mr. J.K. Paria today submits that though they have been informed that certificate has been issued, the NET has been issued till date, the same have received. This is matter on Monday, as there's no appearance behalf of number 4 UGC as a fixed case. Yes.
This is number 3.
Yes.
That's number 3.
Hello, Braj.
Lordship, respondent bank would require some more time, Lordship.
The thing is that because this involves two branch, Ranjab branch and Maulai branch.
The HDFC?
We are HDFC.
I think HDFC is something very wrong in your functioning. Something really wrong. Something not right and not wrong. Sorry for the wrong use of words. Something's not right. You can't even coordinate between two branches.
That's what we were doing, because this is done by one office headquarter to get those transactions, because a lot of transaction during the service of the respondent, private respondent. So we yet to compile all those. We have done to a certain extent, but we have to compile and check.
I pray for only 1 week time, Lordship. Private respondent fell ill, Lordship. That's why some details couldn't be obtained. I'll file it positively, Lordship, before next date, Lordship.
For us, at least 2
Mr.
weeks.
Hazarika, you filed yours? Reserve Bank?
Yes, Lordship. I have filed actually the 5th of...
You pay some cost for the delay. If you pay cost, I think maybe expedite things.
No, again, this is beyond my control.
Not you, Mr. Hazarika, the HDFC. So you
But
pay
just
some
give us
cost.
just a final chance.
Pay some 50,000 for legal aid.
I'm sorry, Archie, that again, it's also beyond our control, because the transaction is
To pay cost.
No, not for the cost.
If you know we ask
us a final chance.
or we direct for paying cost, we see that or to appear in person, and the person is giving instructions, the affidavits come like this. But if we keep on giving time, mechanically, it's just it's just
A final chance may be given, last chance, opportunity. Positively, it will be filed.
That will inflict cost.
Again,
how much cost should we give, Mr. Lasonglia? By your estimate?
I'll leave it to your discretion, Lordship.
By your estimate, how much cost will be inflicted?
I don't know, Lordship.
I don't know.
Give us
You're
a 10
scared, Mr. Marpan.
No, Lordship.
Give us 10 days, positively.
Ms. S. Marpan has yet again renewed a prayer for filing affidavit. So I've seen also similar prayers also made by Ms. S. Pandey in house number 7 stop. It is noted that innumerable opportunities have been granted, but till date the affidavits have not yet been filed. Further 2 weeks time to grant it is expected. That on next year affidavits will be on board, or else other orders will follow. Yes.
Thank you.
Yes. Yes. The affidavit on behalf of support number 6 is already been filed. Yes, Mr.
Please, Your Lordship, I'm praying for some more time, Lordship, to file the affidavit.
Lordship, this due to bona fide mistake, we have not taken the step. 5 to 7 may be allowed to take a fresh step.
Why bona fide mistake?
We overlook.
It's not a mistake.
It's not actually.
That is what?
Overlook, Lordship, that's all.
For what to take steps?
Yes, Lordship.
Okay. MS NG Shilla so and so. PS4 are for 2 weeks time to file affidavit stop. Subjects of duty. Inadvertence.
Yes.
Steps were not taken on the remaining
5 to 7, man.
5 to 7. He is allowed. His directive takes within 3 days.
Lordship.
Much obliged, Lordship.
Much obliged, Lordship.
Yes, there's some hearing matters. We are going to take up evidence now of witnesses who have come.
Lordship, item number 13, can you have it after 2 weeks, Lordship?
13 is which case?
This matter
I'm
pertains
the
to...
Lordship for the government.
No urgency?
No
There's
urgency.
no urgency. He was not given appointment because
Other
he is
two matters?
overaged.
Obliged, Lordship.
May I please, Your Lordship, I want to finish it up, but do it leave up?
Finish it up.
Yes, Your Lordship. Because, Your Lordship, petitioner has already crossed 60.
Number 10 is which one?
And since 2023, Your Lordship. And
that is regarding that project, Your Lordship.
Project.
Where the university has nothing to
Yes,
do, my lord.
but
See, one thing, just we'll have it because today we will press for time. We have to take evidence and we have some interviews.
yes, Your Lordship. So any date may be convenient date, short date may be given.
After 1 week.
We'll do
Yes,
it.
after 1 week, yes. Number 10. And the last one?
There is another supplementary, number 7 in the supplementary list, Your Lordship, regarding that.
It's regarding the project.
Construction of
constructions
road
in Nongstown.
without having invited tenders, Your Lordship. And
It's very urgent.
yes, because the work is already over, Your Lordship.
No, Your Lordship, I'm
and
disputing
the purpose
that
for
fact,
which
Your Lordship.
Monday.
Your Lordship.
we want 1 week's time, Your Lordship, because the AG is also not available. AG is
You were
leaving
there.
us in this case.
You're
I'm
double
there.
AG, it's only single AG.
Yeah, he's double. Okay, Monday.
After 1 week, okay.
Okay, 1 week.
Your Lordship, can we fix on Wednesday? Because there's no division bench on Wednesday, so
Yeah,
in
okay,
that way.
There's no division bench of Justice Bhattacharya and Dingdao will be sitting. And I have 2 appeals, Your Lordship, before the division bench.
I was thinking about this
Then
court
1
not
week
having
will be
division
okay.
bench. 1 week.
1 week.
Your Lordship, further no extension after that, Your Lordship.
1 week, yes.
Highly
The
obliged, Your
matter is
Lordship.
infructuous.